evidence. The statute before the court in Urias-Zacharias, which was the predecessor to Section 1252, B4, also, it didn't say the asylum eligibility determination across the board. It applied only to findings of fact, and that's what this statute says as well. So we think the government is just over-reading that decision, and the government doesn't really—
I think you may be under-reading it. There was no factual dispute in that case. Everyone agreed on what the guerrillas said to the petitioner. There was no dispute about what was said or what happened. Instead, the question was whether those undisputed facts met the standard of persecution, quote, because of political opinion. So I don't see how that's not a mixed question of law and fact, and mostly a factual question.
No, Justice Sotomayor. The dispute in that case was about whether as you said, was whether the persecution was done on account of the non-citizen's political opinion or something else. That is a question about what was in—
But there was no dispute about the facts. What was said was undisputed. And so the question was, did that meet the level of because of?
No, Justice Sotomayor. The facts of the case, what was said, what was done, as Justice Gorsuch pointed out in the earlier argument, subjective intent is something that you infer from facts on the ground. So in a murder case, you might know exactly what happened, who showed up when, who fired first, but I don't think anyone would say that the facts are undisputed in that murder case if we haven't figured out whether the defendant had the intent to kill or not. And that was the same issue in Urias-Zacharias.
So what's different between what was said or done is undisputed in this case, what he was told, and the question is, did he have a fear for his life? How is that any different than what happened in Urias-Zacharias?
Because that's actually not the question in this case. This is a past persecution case. Under the INA, a non-citizen is presumptively eligible for asylum if they have suffered persecution in the past. It's not this forward-looking inquiry about whether they have a well-founded fear of persecution going forward. That's a different kind of inquiry, and I agree with Your Honor that it goes to their state of mind. It involves the calculation of a future probability, and so the case for substantial evidence review would be much stronger there. But here, where the facts of what happened to my client are undisputed. The immigration judge took his testimony as credible and true, and found that the death threats he experienced were indeed credible and menacing, but nevertheless held that under the law, they did not rise to the level of persecution.
No, but you just said there